May I permit to mention a matter for inclusion in the list, Lordship, MSCC case, Lordship, for hearing, Lordship.
There are lots of
Lordship, kindly,
matters.
time I lack, Lordship. Kindly,
Where is the time?
Lordship, kindly list in the list, Lordship.
This section.
166, Lordship.
166.
6. Yes, Lordship.
What are the grounds for appeal?
At the one matter, Lordship, income, and one matter is the injury case, Lordship. The disablement, challenging the disablement, Lordship.
Very difficult. Only
Lordship,
one
let it be in the list, Lordship.
case.
Let it.
That case is. There is no time. There are lots of matters pending already.
Lordship, let it be in the list, Lordship. Time I lack, Lordship.
What is the purpose of listing only? Only one.
Lordship.
Yes.
Item number
One.
1.
I'm before your lordship against an order dated 3rd of February
Section
2000.
5 application is
Yes,
there.
yes.
So you have to serve the section 5 first.
Service kara hai nahi?
The section 5 without serving other side, how I can allow the condonation of delay?
Admission now. My thing is this, I'm for the past 3 years.
Whatever may be, but your revisional application filed beyond the limitation. So you have to first satisfy this court with regard to the condonation of delay, and for that other side is required to be heard. An opportunity should be given to the other side. Within time, then there is no question of service.
Item number 2.
It's matter on the earlier occasion, that is 38 June law directly serve the copy to the learned advocate, contacting advocate of the trial. Because under the I serve the certificate of service, but the opposite party did not appear. Under there is a direction by the law. I served the Malad, I went to serve the copy, he refused. Therefore, Malad, I posted it. But that
Service has not been received.
day after tomorrow, in the meantime, that will be effective.
Because it would be not possible to reach the postal track by tomorrow.
Item number 3. Item number 3.
The 3, I appear for the opposite party. 3, I appear for the opposite party.
Oh,
No, other side is already there. Yes. Transfer of the suit, matrimonial suit. What are the grounds for transfer?
Basic.
Yes.
Wife is deciding strong and she is not taken by her husband.
Learned friend, can you please take the microphone so that I can hear you?
She has no independent source of income. His permanent resident parental home is Jalpaiguri town, and since her birth she is born and brought up here. She is not also familiar with the ambience of Calcutta, and she is only offspring of their old ailing parents. Mother is totally bedridden. Father in the 25 due to heart problem, 4 stents was implanted in her artery, and he came. Apart from that, she in the 25 she met with an accidental injury in ankle, and he is not able to move freely like a normal man or woman.
So that is the 2 grounds. Number 1, long distance.
Long distance.
He cannot travel up to the Howrah.
Ah,
And another ground is your parents is ill.
ah,
Nobody is there to look after.
ah.
These 2
Apart
grounds.
from that, financial.
Financial
constraint
position
is-
is also not there.
ah,
No, if they will provide you the finance, then you will
No,
go
no,
to
no,
the
no.
Howrah.
No,
Even
It is not-
finance provided by them, you will
no,
not
it
go.
is not possible.
So
I
where
am-
you are wanted to transfer that
I am
from Jalpaiguri.
Howrah to Jalpaiguri district judge.
Jalpaiguri. And you reside in the Jalpaiguri.
Right.
Yes.
I stay in America. That's the whole difficulty. That's the whole difficulty. As following from your lordship, that I can provide my expenses to travel. I understand the other difficulties also. But I want to resolve the issue. If there is any possibility to resolve the issue, I'm ready to. In any terms and conditions, if they come up with a reasonable terms and conditions, I'm ready to. But
You have
ultimately,
filed the
this
matrimonial suit
Yes.
for divorce.
divorce.
So
But
proposal should
what
be
does
from your
what?
side.
But I am ready to. That's why we want to know the reasonable
So
terms
you
and
are ready
conditions
to
they
take
want.
her back. You are ready to take her back.
But I reside in America. But I don't think that could be a reasonable solution. Possibly. But if they
And
come up
what is
with
your
a
proposal of resolution of
but
dispute?
I want resolution. We don't have good relations during our matrimonial life 10 years. But all that we want that
Yes, what is
it
your
should be.
instruction?
Let the suit be transferred here. It is my humble submission before
No,
the.
he is asking about the
Settlement.
Let them
settlement.
come up with instruction.
Ah.
Yes.
Let
Let them
them-
come up with
Whether
instruction.
you want to stay with him or you also want to be given divorce.
No, I have, at this moment, I have
You have no instruction. You can
on this
take
point.
instruction. If
Let-
the
let-
matter
let-
will
let-
resolve.
Let them come
the
back tomorrow,
matter will
Milak.
resolve.
Then,
So there is no question of
then
transfer.
one-to-one discussion is necessary at the first instance.
1-to-1.
Yes, let the husband come here. And he is
But we can do it.
financially sound.
But kindly
He
pass a
resides in America.
Yes.
one line order that we can do
But
it
is,
online.
I am acquainted with.
At least your offer should be given to him. What is your
No,
prayer?
no,
Whether you will reside with him
No, she.
Or get rid of
My,
marriage.
my husband and his parents-in-law, when I am met in accident and my surgery was done in Manipal Hospital in Calcutta, after that, I went to my matrimonial house,
They did not
but they
take care.
insisted to go to my parental house.
Okay, that is the only.
And my husband also endorsed that. Their parents' insistence, that you go to your parents' house.
So have you heard the submission?
Yes, but I have
Mr.
heard, I
Salim?
understand that, I understand that there is no way of resolving the issue, and possibly she will not come back to me also.
There are a way of resolving, but you have to approach by coming here.
But that is practically not, may I suggest it? But the landed lawyers for the parties can take instruction and can sit. Oh, I cannot see your lordship, but I can make submission, that.
Okay, I am giving direction to take instruction.
Instruction that all that we can do in the meantime, with my proposal is let the landed lawyers for the parties sit once, either online or with the parties. This one line
ask
direction
your
will help us.
friend, where is the convenience? Ask your friend.
Sir, online
Ask
we can
your
sit, sir.
friend.
At
I'll
this
share- I'll-
moment, I have no such instruction. So I have to take instruction from my
At
client.
least instruction is
Yes.
required from the
Yes,
client.
let-
Tomorrow
My
for the
humble
instruction,
submission, first instance, let the suit transferred here.
No, that's the
And
final
And then
prayer.
online and offline.
Before submission on merit, he asks for proposal. Because matrimonial suit court always try to resolve the
Right.
Yes,
dispute
I have,
prior to go into the marriage.
Yes,
Always we try. Even in the trial court, we fix the date for reconciliation.
reconciliation
yes.
in the Marriage Act.
So
That's
we
the-
try our level best to resolve the problem.
I absolutely agree with Lordship.
So you take instruction one day. No,
Let it be
make
tomorrow,
such
in the meantime,
difference.
let him take instruction. Yes.
Tomorrow, can you take instruction?
Day after.
Day
tomorrow.
after tomorrow.
As your lordship pleases.
Item number 4B5.
Lord, I am for the petition. May it please your lordship, Lord, the affidavit of service, no? Oh, Lord, the respondent number 4, Lord, who is the pro forma defendant, Lord, due to insufficient address, it has not reached him, Lord, as per the track report. However, Lord, the other respondents, I believe, are represented by Mr. Ghosh. Lord, this is an application, Lord, for transfer of proceedings to a court outside the judgeship of Alipurdwar. Lord, the facts in brief is that the opposite parties here in Lord, they are the plaintiffs before the learned trial court. Lord, petitioner number OP number 1, 2.
You are the
I'm the
plaintiff in
I'm the
trial
defendants.
court.
I'm the defendants.
Defendant.
Yes. Milord, the OP number 2, OP opposite parties are Milord the plaintiffs, and they are practicing advocates of that very court, Milord, of the Alipurduar court. And Milord, they have substantial influence, Milord, in the local bar, being local practicing advocates. So
Suit for
Milord, permanent injunction
declaration and injunction.
and injunction. ওটা তো ওদের করা। Yes. Now, Milord, my transfer proceedings, transfer
Only ground is that he is the practicing advocate of that court.
No. That is not the only ground. The ground is that, Milord, 2024, the suit was filed. For the last 2 years, Milord, we have tried to contest the suit. Milord, almost, Milord, 3 sets of lawyers were engaged, and
From
ultimately
their side.
from our side. And ultimately, Milord, all of them, Milord, have retired from the case, saying that there are tremendous and external pressure exerted upon them by the plaintiff side. And as such, since they are the local members of the bar, they are unable to represent us. The situation is so bad now, Milord. Even the first order passed by this honorable court, Milord, that order had to be communicated through the special messenger from this honorable court. We have no lawyer there in the trial court.
Nobody is ready to.
Nobody is ready to take our brief.
represent you.
Yes. This is the, Milord, problem. Milord,
The case is pending in Alipurduar.
in Alipurduar.
From there, where you want to.
Milord, anywhere outside Alipurduar যাচ্ছি.
Alipurduar.
Yes. Milord, since it was a part of Jalpaiguri district, Milord, if it is transferred to Jalpaiguri, it would be convenient, but I leave it to your lordship's discretion, Milord. Milord, there are judgments by the Honorable Supreme Court, by different high courts, Milord. I will be placing, High Court, Punjab. Milord, Punjab and Haryana High Court, very recent judgment passed in 2025. Milord, if not, Milord, exactly identical, Milord, it is almost identical. Unreported copy. Milord, very similar allegation. In this judgment, I rely on para 12, Milord. Para 12.
76. Milord, so far as item 4 is concerned, it is with regard to the appeal, which is pending before the district judge.
Fourta suit.
There are, I think,
Five
2
times.
applications.
Two application.
One is for.
First is the suit, and
another
second is a appeal arising out of that suit.
Both.
76.
Yes.
Huh?
Both will be transferred in different 2 courts.
Yes.
But 76, as you have served upon me, it is the appeal. 76.
Appeal pending before the district judge.
Appeal
Before the district judge, yes.
That is item number 4. And with regard to the suit, it is probably item number 5.
No,
That is pending before the trial court.
CO 78.
That is pending before the trial court.
78. দেখো একবার।
78. Again,
Both he
76
wants to
charge.
transfer.
Yes.
That I understand.
But kindly have a look at para 12.
Yes.
Well, it says, in view of the rival submissions aforesaid, it is pertinent to mention that while considering the application for transfer of any judicial proceeding, various circumstances ought to be taken into consideration. There is no cast iron formula for considering the transfer applications. Each case has to be decided on its own facts and circumstances. One distinctive circumstance in any case may lead to a different decision in the transfer application. But anyhow, underlying principle is that justice should not only be done, but it should also appear to have been done. There is a categoric assertion of the applicants about apprehension of exercise of influence at the instance of Madhubala, member of the local bar at Garshankar. However, it may not be so, as the courts are required to work without influence of any person and give a decision in accordance with law. However, when the entire bar had gone on strike, as evident from Annexure P4, which is memorandum given by the bar to the subdivisional magistrate, the reason for apprehension in the minds of the applicants is seemingly genuine. The interference of the bar cannot be ruled out, though it may be with the sole purpose to support the bar member. This is definitely going to cause inconvenience to the applicants at one moment or the other. Considering the aforesaid circumstance and balancing the inconvenience of both the sides, both the transfer application, that is TS so-and-so and TS so-and-so, are partly allowed, and the civil suit, that is CS so-and-so, title so-and-so, and the civil suit so-and-so, titled so-and-so, filed by the respondent, stands transferred from the courts at Garshankar to the courts of competent jurisdiction at Hoshiarpur. The requisite records of the aforesaid cases be sent by the court concerned to the district and sessions judge Hoshiarpur. So, my lord, the facts are almost identical. The only
In
difference
your
is
case, if suppose some advocates do not represent you, you can hire the advocate from other district.
but that
You
is
can take-
but that is not a cost efficient exercise first. Second, even if I have to hire an advocate from other bar from outside the district, Lord, I have to keep a local advocate there. Why I am saying so? Here your lordship is dealing with only 2 applications. There is one more application in which, my lord, this honorable court granted me liberty to file a restoration application before the trial court. No one was ready, my lord, to do that even. My lord, my associate from Jalpaiguri had to go there. My lord, he was severely resisted even from filing the application because he is not a local bar member. But anyhow, on my intervention, on the intervention of the court, one of the judicial officer, my lord, prevailing there, my lord, it was finally filed. The
Filed.
restoration application was finally filed. But ultimately, if this is the situation, my lord, from a
Bar.
yes, from the bar, my lord, how come, my lord, this suit will be dealt with by that court there?
Yes,
Millard, now, my only submission is, Millard, both these applications are absolutely frivolous and filed on the basis
no,
of
that is on
perception.
the merit. We are only
Yes.
concerned
Millard,
about
I
the
am saying
transfer on
this,
the
Millard,
ground
now-
of that he
Millard-
is unable to engage
No,
any
Millard, this is
advocate.
absolutely a
And
false
number one,
statement.
even
This is
if
absolutely a false statement
he
because
engaged 3 occasions.
Millard,
that
no,
those
this is not
advocates-
correct. Let him, Millard, this is not correct. Kindly seize the records. Millard, we will go by the records. From the petition, from the application, kindly seize the grounds which he have stated in favor of his claim for transfer. Kindly, Millard, flips through the grounds once. But I will show a Supreme Court judgment where the Honorable Supreme Court has said that transfer cannot be on mere asking. You have to show the specific instance how justice will be, Millard, obstructed in that particular court. Otherwise, you can't come and just say an advocate is a party, therefore I want a transfer. Now,
No, 3
a statement.
occasions, 3 instances, he appointed advocate.
let him
Why?
show from records 3 wakalat
That is
namas.
his submission.
Submission will not do. My submission is he is duly represented by the learned advocate who is a member of that local bar. There is no difficulty
Please
whatsoever.
show me the grounds.
Kindly seize the grounds. Item number 4, Millard, CO 76, if Millard takes. Para 4 onwards.
76, you are showing 76.
76, 78, more or less same. Millard kindly show, Millard kindly just seize.
Round number 4.
Para number 4. Overwhelming influence exercised by opposite parties who are influential members of the local bar association. Para 5. Continuously manipulating and influencing fellow members of the local legal fraternity. Para 6. Several learned advocates practicing at Alipurduar became unwilling to accept the brief. Now, if this is so, how he is represented? It is not a case where he is without a representation. Para 7. Learned advocates engaged by the petitioners facing professional pressure, hostility, indirect coercion. Para 8. No requisites could be filed because of the extraordinary circumstances prevailing within the local bar. So these general statements won't do. The judgment cited, there was a specific incident which had happened, which gives the perception that justice can be obstructed.
Please show me how many advocates you have appointed.
If
time
my
to
lord
time.
is seeing which file, my lord, is it CO 78 or CO 76?
76.
76.
Yes.
Appeal.
Lord, kindly
Please
come
tell
to.
me from the
Yes,
orders.
yes, from the
that-
records I'm showing your lordship, I've annexed everything, Lord.
If 3 sets of lawyers have appeared, that will be reflected from the order sheet.
Yes, yes, from the, my lord, we have filed the wakalatnama, page 21.
This is one set. Now, where is the second and the third set?
Page 22.
Lots of advocate.
Page 22.
Yes, page
And-
22 is before the additional district judge.
No, no.
The earlier one is before the lower court
No,
probably.
no, no, no. I am.
Civil Judge Senior Division is 21 and 22 is also Senior Division.
And page 24, third set.
And 24.
Key there is
Civil Judge
copy
Senior
by.
Division, yes.
Which page number?
24. 24, 22 and
78 দেখছি, this is 76.
76. Please come to the CO 76.
Yes,
Page number 21. Something is wrong.
but 21 is an order sheet.
Record is something missing.
Yes.
So three sets of lawyer has been engaged. time
Yes,
to
in
time.
which court?
Before the
Yes,
civil judge
Civil
senior
Judge
division.
Senior Division.
Yes,
All,
so-
all three. All three.
Maybe he
Civil
has,
Judge Senior
thought
Division.
it fit to change his advocate.
Yeah.
But where is the incident that he has been obstructed to render legal services? Then if that is so, how lawyers are being engaged? All local advocates?
Milord, for the last 2 years, we have tried our level best, Milord, in getting.
Milord,
Milord,
in
the
my,
best
Milord, I don't know,
representation we
Milord,
could.
I don't know what he is showing to the court. In my brief, page 20 is an wakalatnama, 23 is an wakalatnama before the additional district judge.
But Mr. Ghosh is getting confused between both.
No,
the
no,
matters.
I am not getting confused. Both the briefs, you take my brief and see it. Page 23 is a wakalatnama before the additional district judge.
This is 78.
হ্যাঁ,
This is 78.
উপরে 76 লেখা।
এটা আমাদের সার্ভিস
কি? হ্যাঁ, তো হ্যাঁ, which one are you referring to?
78, all are before the additional district judge.
Yes.
হ্যাঁ,
And 76, all are before the civil judge senior
so
division.
that is not so in my brief.
No, no, it is there, Milord. We have served it.
Are what do you have, sir?
I have served you. Served. Now, Milord, one
You
thing.
take my
One
brief
thing.
and.
Milord,
No, no,
one
Milord,
thing I
not
ta-
in this manner, not in this manner. I will apprehend that I am being
You see
misled.
the brief, see the.
Milord, I will apprehend
Please
that I am
service
being
protocol.
misled.
Milord, we have served the opposite parties directly. Mr. Ghosh has requested for an additional copy. We have provided him a soft copy. The printout is taken by him. So, Milord, what he has.
No, no, this is what you have
don't
served
know.
upon the
And
client.
ultimately, Milord, what Mr. Ghosh was, Milord, objecting, Milord, his objections are no more sustainable, Milord, in.
Let him satisfy with his brief.
It is
first.
78, so. This is 76.
70,
Yes.
78 is relating to appeal and 76 is relating to
True.
trial court. request.
Very well, very well. Now, Milord, in 76.
In both cases, there are lot of Okalatama filed by them.
Yes, page
And
20,
since
Milord,
2000
in 76, page 20 is a wakalatnama. Milord, kindly comes to page 20,
In 76.
page 76.
Yes.
Yes,
Yes.
page 20 is a wakalatnama before the court of the district and sessions judge. Milord, kindly seize the seal, page 20. They have several matters
No, no,
pending, Milord.
20 is the order sheet. 21 is the Wakalatnama.
এখনই তো 78 কেটে ও বললো
Why
এটা
you
76
are confusing?
No, no,
Come
Milord.
to the CO 76.
Yes,
one by
I am
one.
in CO 76.
6. So you come to the page 21, Wakalatnama is there.
Even in CO 76, Milord, page 21 is an order sheet, not a wakalatnama.
So
Wakalatnama is a page 20.
something is missing while making Xerox.
Huh, no.
Which court is the suitable for both sides?
No, Milord, for me, I am, Milord, opposing the transfer because one of the main plaintiff, he is an 87-year-old advocate. Milord, kindly seize the judgment of the Supreme Court. Milord has to balance
Milord,
both sides.
even my
And
clients,
merely
Milord,
so, Milord,
even my clients,
That's why I'm asking both sides if there is no any problem. then-
even
Milord, there is
my
no
clients,
problem.
Milord,
The problem what Mr.
two of them are
Chaudhary
senior
is-
citizens.
Milord, Mr. Chaudhary is arguing, Milord, it is an apprehension. Kindly seize, even going by Mr. Chaudhary's brief, 21 is an wakalatnama, my lord, signed by one set of defendants. Page number 22 is by another set of defendants.
Yes. On page 24.
Vimal Roy 1 to 6.
Yes,
My
Ah,
clients, my lord, the petitioners
These
before
are
your lordship.
the defendants.
yes.
Yes.
1 to 8.
Yes.
26.
24 দেখো তারপরে আছে।
Did you lodge any complaint?
No, nothing.
5 complaints against me. 5
No, no,
criminal
did
cases
you-
against
did
me.
you- Did you raise any complaint with regard to their?
My lord, we
No,
have, but
no.
those things are not
No,
documented.
Why
This is
you
the problem.
have not raised any complaint before the
Before
Bar
whom?
Association?
Before the bar association, my lord, bar is controlled by them. My lord, just imagine
how
my
bar is controlled by
situation.
them?
Just imagine my situation, my lord. Few farmers, my lord, who are fighting for their rights, whose land has been grabbed by an advocate. My lord, they are unable to get a legal representation
My lord,
in
we
the
are
trial
not-
court.
my lord, we are
And
not
this is
going
the
into
way, my
merits.
lord, we are resisted.
My lord,
My
we
lord,
are not
one of
going into
one of
merits.
my application, my lord,
Who
has
has
been
done
dismissed
what
for
is the
default.
subject matter of
Even
this?
after, my lord, I was there to file wakalatnama. I was prevented outside the court. My lord, this is the
Unheard of.
condition in the.
Unheard of.
You have been prevented to go to court.
Yes.
Why you have not lodged complaint against them?
Who will lodge the advocate?
You
My lord, they are
should lodge
scared.
before the.
My lord, my lord, my
police
clients are
station.
scared. My clients are scared to go to the court premises. This is the condition.
If your client is scared, then.
My lord,
you
more
cannot
than
come to the
15,
court.
20 advocates, my
cannot
lord,
come to the
they
court.
make a group, they go to the court and
If
my lord,
you
they
have
prevent.
been prevented by any lawyers to go to the court, you will not take any action. Last 2 years, you are.
Lordship has to,
you are-
lordship has
you
to,
are
lordship has to
sitting 2
see,
years.
lordship has to see who is before
At
your
least
lordship.
Bona fide, you have to.
My lord, your lordship has
made.
to see who is before your lordship. Few farmers, my lord, who are illiterate, who are lay people, my lord, who have no knowledge of the
Now
law,
you see
they are
every-
before your lordship, they are fighting with a set of advocates, my lord, who
Now-
are influential in the land
Now
trial
you
court.
have to see 81 years lawyer.
He is 80, if he says
87.
he is 87, my lord, my clients are also senior citizens, 2 of them.
And my
Where
lord,
will
the
I go, my lord? After 2 years,
apprehension-
I have come before
my lord,
this
the
honorable court.
apprehension has to be specific. Now see the first wakalatnama, engagement in February 2024.
Both should go to the Kuch Bihar.
My lord,
I will
second.
send both the cases in Kuch Bihar.
No, no,
Let
my
it
lord,
be, my lord.
my lord, no.
Let it be.
Kindly see the second wakalatnama.
From Alipurduar,
No, no.
Kuch Bihar is very less.
Millard has to first
Very
satisfy,
fair,
Millard has
very
to
close.
first satisfy that there is a ground for transfer. The second wakalatnama, engagement in 2026. If the apprehension was so, I take it to be true, if the apprehension is so grave, after 2 years you change your lawyer. So how can one
Yes,
say,
because after 2
how
years,
can Millard, how can one say that this is due to the
because
professional?
there was, my lord, reasonable, my lord,
And where is the ground stated in
apprehension.
the petition?
every, my lord,
Grounds
kindly.
is there, ground
Grounds
has-
are there.
All omnibus grounds.
Oh, omnibus.
My lord,
General
what more do I need
apprehension,
to bring before this
threat,
court, my lord? My lord, my
apprehension
arguments
threat.
are
So,
on oath.
Any advocate, if he becomes a plaintiff and the defendant, other side on asking has a right to.
No,
seek
cannot
transfer.
be. It's not about
That
any
should not
advocate.
be, that should not be, but.
So where is the ground? I'm asking to myself. Millard must satisfy. Millard, the judgment of the Supreme Court clearly says there has to be a
Please place the
specific
judgment.
incident.
Please place
Where
the
you have
judgment.
pleaded in your applications that they have threatened or they have influenced the advocates, which
para-
grounds?
Para. My lord, I am showing you, lord.
Millard, kindly see
I am showing you,
says
Lordship.
this judgment once. Before Millard goes any further, kindly see this judgment. Para 23.
My lord, we are also relying on that judgment, my lord. My lord, para 11, para 10, para 11,
Para 11, para 11,
yes,
76.
76. Page number 7, para 11, para 12, para 13. Para 14.
The learned lawyers have appeared. They are contesting all the proceedings. All of a sudden, after 4 or 5 years, you come and say that you have been threatened.
Which paragraph you are relying?
I am relying on para 23.
Thank you. Lord, even we are also relying on that. Let my learned
Milord,
friend
the last
demonstrate.
line, if on the above or other
So your
relevant
first, how
considerations.
many judgments you are relying? First one you have referred?
Milord, one Mr. which Mr. Ghosh
No,
is
no,
relying-
first you like which judgment? you
that
are
is
relying?
Milord Punjab and Haryana High Court. Milord.
One you have given,
Omkar
another
Singh.
one is?
One Singh, another in Kulvinder Kaur, Milord, what Mr. Ghosh is also relying. Acha. Another is Milord Patna High Court,
Yes.
a very decisive one, Milord, a reported judgment
You
of
have
the court.
relied Punjab and Haryana and thereafter Patna.
Yes,
Partner একটা copy দে। আছে?
reported আমি
Which
citation.
paragraph?
Yes, citation.
Lalita Rajya Lakshmi?
Milord, para 20 and 21.
Okay, another judgment? Do you have any other judgment?
Milord, the Supreme Court judgment, Kulvinder Kaur, para 23, 24 and 25. Mr. Ghosh is only relying on the last line of 23. The judgment copy though, Kulvinder. But he has already given para 23, 24 and 25.
This judgment is relying by both the parties?
Yes,
You are relying which paragraph?
23, 24 and 25.
And you are relying which paragraph?
Milord, I am only relying on the Supreme Court judgment, para 23.
23.
Yes.
23 only says, Milord, there has to be a reasonable apprehension in the mind of the litigant.
Correct. That's the point where I am on.
And the reasonable
this
apprehension has been
apprehension-
demonstrated, Milord, in my
and
application,
this-
Milord, with cogent evidences,
The evidence. Milord,
documents on record.
Milord, let Dr. Chaudhary finish, Milord, I will make my submissions there.
Any other judgment?
No, Milord.
Yes. So, Milord, the point, the Punjab and Haryana judgment which has been referred, a specific incident. The entire Bar Association has
Entire
gone
Bar
in strike.
Association reference.
Distinguishable in facts. Distinguishable in facts. Supreme Court says in the mind of the litigant, there has to be an apprehension,
That
which is
justice will not be.
justice will not be subserved, and that has to be borne out from records, circumstances, that yes, reasonably justice will not be subserved. Here, the only ground, the best point that he has raised is 3 sets of advocates. 3 sets how? First Wakalatnama engagement in February 2024, page 21. Page 22.
After long gap, second.
No,
one.
not long gap. Page 22 is engagement by 3 different defendants. It is not that the same set of defendants are changing the advocate. Different set of advocates engage someone else. Page 24, engagement in April 2026. They have changed one set and engaged someone else. So the first statement which comes out from his mouth that 3 sets of advocates have been changed appears to be contrary to records. Therefore false.
This is misleading.
Therefore false.
This is misleading.
If 3 sets of advocates are changed, there should be 3 sets of wakalatnama on behalf of the same set of clients recorded in the order sheet. And records are contrary to that. So if someone is represented for 2 continuous years, then one fine morning I feel I will engage someone
4
else.
years he has represented, 4 years.
Yes,
Since 2024.
since 2024 to 2026.
Bimal Rai appointed in the year 2020.
24.
Case number 24, 8/4/2024. It was accepted by the Learned Council.
Yes,
Deepa Mandal on 8/4/2020.
yes,
And thereafter, in case number 21, Bimal Roy again appointed another advocate.
in
on 19
2024.
to 2024.
24.
4 years, one lawyer has been contested.
2024 case.
That is
2026.
26, 2 years.
2 years.
One advocate has represented you. And furthermore, there is no any complaint.
No complaint.
Either in court, either in bar association, either in local police station. No.
My lord has to
no
consider the
complaint
ground
was-
reality.
Yeah.
My lord, the Bar Association is controlled by them. Where do I lodge a complaint?
No, who
Suppose
is he?
Tomorrow I will transfer Kuch Bihar. Again, similar thing will happen. You will not take
No,
any action.
no. In Kuch Bihar,
Again,
there is
you
no
will ask
problem.
for
In
transfer.
Jalpaiguri, no problem. In
You
Darjeeling,
must
no
have to
problem.
satisfy the court
My lord,
that yes,
if the materials, whatever has been produced before your lordship, if this is not sufficient, Milord, then I ask myself, what more material is required for a transfer of
Just
such nature?
now
Milord?
you have submitted 3 wakalatnama, you have, on 3 occasions you have appointed. From
Yes,
3 wakalatnama,
yes.
your own statement is contrary. to
No,
those.
it is not.
You
How?
see,
Yes.
is come to page number 21. Who appointed the advocate?
Yes, Bimol Rai, Shamol Rai, Profullo Rai, Swapna Rai, Phula Rai, Sadhana Rai, Josna Rai. Yes.
And page 22, who has appointed?
Who has appointed? The second one.
Giriwala Rai, Geeta Rai, Josna Rai. They are also parties in the first Wakalatnama.
So why not all engaged? Why 3 only came out from your group?
Milord,
and
they are
engaged
all,
another
they are,
advocate?
they are all,
So
they are all-
other defendant were represented by the learned counsel.
no.
There is no any
No.
influence or any type
And
of.
finally, Milord, finally in the fourth, Milord, what more should I do? Milord, I was
You
trying my
have to
level
do
best.
more.
I was trying
You
my
have to
level
do
best. Then
more
Lordship has
against-
to,
Suppose if I
Yes.
transfer this case from Alipurduar to Kuch Bihar or some other district, similar thing will happen. So you will.
how could Milord similar thing will
You
happen?
will not
They are not
raise-
local
raise
members
any
of,
objection before anyone, either in court. Why you have not mentioned? this
similar
before
thing
the
will
court?
not happen
Why you
because
have
in,
not made any application before the learned trial?
Milord,
court?
I have
District
told,
court?
I have told your Lordship what
Why
is the
you have
situation.
not
I have told your
made
Lordship
any
what is the
application
situation
before
there.
The bar association against him. Bar
Milord,
association will
Milord,
take
from
action.
the daily order sheet,
Number third, you have said they have prevented or restrained to go to court. Why you have not lodged any complaint before any?
My
local
lord, the
No, no, Milord,
difficulty
from
is
the
your
order
Lordship
sheet-
is not stepping in the shoes of the
Milord,
litigant and see
from
what
the-
they are facing.
Milord, from the
Milord has
order
to see the
sheet-
ground reality. Milord, these people,
Milord,
I have-
they are contesting with, Milord, the learned advocates who are influential. Milord has to keep this in consideration, Milord.
Milord, from the
Milord,
order
few
sheet, let him
illiterate
demonstrate on
persons,
which date he was
Milord,
prevented from
Every
taking
advocate will
steps.
influence the court.
No, I am not on the influence of court. I have
Even if
never said that the
influence, you
court is
have to
influenced.
show the bona fide.
I have
Where
never.
is the document? Where is the,
Milord,
your
from the order
case?
sheets, Milord, from the order sheets, let him demonstrate on
Sir,
this
please.
date. I could not
Sir,
take
please.
steps before the
Please,
court.
please.
Milord, another petition that has been dismissed for default. 3 dates, 13th, 19th and 20th of June, na? Of June.
You are unable to file
June,
application.
May, sorry.
I heard.
Yes.
What steps you have taken? An advocate will not
Milord has to
represent.
consider
If
the,
advocate-
Milord has to consider, it is not the advocates who are before your Lordship.
All
It is-
advocates are impartial. All advocates.
Milord has to see their status.
That is their
Milord
own
has to
choice.
see their status. The ground realities
if
cannot be
someone-
ignored by this
If
court, Milord.
someone resigned from your case, that doesn't mean that he was influenced.
No, no, the second set came in.
Then what is the,
So how is he prejudiced?
what is the remedy, Milord, coming out from these proceedings? What should I do? Milord, then I have to, Milord.
From here, I cannot give you advice.
Exactly. No, I am not seeking for advice. I am seeking
If
for outcome
suppose
of the
someone
proceedings.
restrained from
Today,
walking in.
today, if
in
your
the
Lordship
road.
dismiss my application,
Suppose-
Milord, what should I do? I should
Suppose
leave
tomorrow
contesting the matter.
someone restrained from going outside from your residence. What is your remedy? What is your remedy?
Milord,
In
no
that
one has
case-
stopped going me from the, restraining
From
me
your
from going
residence
outside
from
my home.
outside, then you will.
The
what you
situation
will
is different, Milord.
Similar
Situation is,
situation is
the
there.
situation, what is falling
You
from
are
your Lordship.
engaging the advocates. They are threatening or influencing their friends, learned friends. They
And
are
Lordship,
resigning from
Lordship
your.
says that I should go and complain to the police.
Why should I say this?
Milord says,
You
where
are
have you
well
complained,
aware
Milord?
that what
There
is
are
the
5
law.
complaints against me.
Are
The
you
police
may-
is against me.
You may file also many complaint against them.
No, no,
They
there
may
are
file also
equal number
complaint
of
against them.
cases and
That
counter
is the
cases.
process of.
There is no
law.
counter case, not a single counter case by us.
Whatever
not a
may
single
be,
counter
anything
case.
more?
No, Milord, secondly, my second submission is, Milord, even if I bow down to this, that yes, under pressure, threat, influence, lawyers are being changed. Now from the order sheet, let him demonstrate on this date, my lawyer was prevented from taking appropriate steps or filing hajira or filing petition. Let him demonstrate one date when the second set of lawyer was prevented. Nothing.
No, influence, only influence.
Influence means what? I will not allow this lawyer. I am a lawyer.
Influence means
Don't go
you-
and
you
represent
can-
him.
You can do not defend
lord,
properly.
so-
That
my
is
lord-
influence.
So, Milord, that is, Milord, something which is, Milord, subjective. your lordship would see whether there is a reasonable apprehension from the records that justice will not be
Anything more?
subserved.
Anything more?
Nothing more.
Oh. Anything reply?
Lord, with respect to Lord, the judgment of the Supreme Court, Mr. Ghosh has relied, also you have relied. Lord, para 23 once I wish, Lord, if your lordship would take a look.
Kulwandir.
Kulvinder Singh.
Kulwandar Singh.
Kulvinder call, sorry.
Yes, 23.
Para 23, Lord, page 6. So it says, reading section 24 and 25 of the code together and keeping in view various judicial pronouncements, certain broad propositions as to what may constitute a ground for transfer have been laid down by the courts. They are balance of convenience or inconvenience to the plaintiff or the defendant or witnesses, convenience or inconvenience of a particular place of trial having regard to the nature of evidence on the points involved in the suit, issues raised by the parties, reasonable apprehension in the mind of the litigant that he might not get justice in the court in which the suit is pending. Important
Yes,
questions.
this is the important grounds.
Yes.
Where is that? You
Yes.
are saying advocates are not representing you in court. But where is your apprehension that I will not get justice from the court?
But
Where
that
is
is
the
the
ground?
implied justice. If I am not represented, that means I will not get justice.
No, when
2
he has
years-
been not
2 years,
represented.
Some
Milord,
lawyers have
2
been
years I have
represented.
tried. Milord, kindly understand the situation. After 2 years, I have come
Now
before
you
this court.
complete first, thereafter you submit.
Important questions of law involved are a considerable section of public interested in the litigation. Interest of justice, demanding for transfer of suit, appeal or other proceedings, etc. Above are some of the instances which are germane in considering the question of transfer of a suit, appeal or other proceeding. They are, however, illustrative in nature and by no means be treated as exhaustive. If on the above or other relevant considerations, the court feels that the plaintiff or defendant is not likely to have a fair trial in the court from which he seeks to transfer a case, it is not only the power but the duty of the court to make such an order.
Okay. Asa, how far from Alipur to Kuch Bihar?
45 minutes.
45 minutes.
45 minutes, almost 30 to 40 minutes.
And how long distance?
Distance
Kilometer?
in kilometer, that's it. Alipur to Kuch.
And from Jalpaiguri to Kuch Bihar?
Jalpaiguri to Kuch Bihar.
2.5 hours.
2.5.
Jalpaiguri to
2.5
Alipurduar.
hours. Milord, I am just bringing to your lordship's notice, Milord, the entire certified copy of the order sheets in the title suit,
Okay, please give.
Milord, which will show that on each and every date they were represented, they have filed petitions, adjournment applications, everything.
Jalpaiguri
And
to
this is, Milord,
Alipurduar
with
is
regard
2
to the
hours
appeal.
40 minutes as per Google Maps. And Kuch Bihar is
You are
40
residing in
minutes.
Jalpaiguri.
If
You are residing in
Yes,
Jalpaiguri.
yes, yes.
And he is residing in?
No,
He is residing in Alipurduar.
Milord, he is residing at a place which is within the Alipurduar district only. The suit property is in Alipurduar district.
Okay, both.
Yes, according to me, Milord, this is only
You are
to
also residing in Alipurduar. Both are residing.
the
No, no.
advocate, the
My
party
clients are
is-
not residing in Alipurduar, Milord. It takes 2 hours to.
Property? Where is
Property-
it?
Property is
Alipurduar.
located in Falakata, within the
Falakata, that is
district of
within
Alipurduar.
district.
Alipurduar.
Yes. And Milord, these are the medical documents
And
of the
Kuch Bihar is Milord
plaintiff.
40 minutes away from Alipurduar.
Medical documents, Milord, 89 years, seriously. ill.
Milord, my clients are senior citizens, Milord. Some of them are senior citizens. They have also, Milord, there are various comorbidities, but your lordship knows in civil proceedings, Milord, regular personal appearance of the parties are not required.
So, Milord, I am only on the point, reasonable apprehension.
Item number 6.
Lordship, in item number 6, I'm paying for next surgery because my senior Mumini Rahman is going to Hyderabad for medical emergency, Lordship.
Medical emergency.
Yes, Lordship.
Lordship, I am on behalf of all the respondents appearing today.
Next.
Item number 7.
My lord, for item number 7, I am on behalf of the appellant, my lord. My lord, this matter, the application has been filed under section 163A of the Motor Vehicle Act, my lord. My lord, the 163A of Motor Vehicle Act has been amended by the government notification dated 22nd May 2018. And according to the said amendment, in case of death, the compensation payable shall be 5 lakh rupees, along with from the date of 1st January 2019, there would be a 5% annual increasement over the fixed sum of interest, fixed sum of compensation. My lord, here is the said notification. What is the name?
Who is other side?
My lord.
Mr. Vikramaditya Ghosh is for the NBSTC, my lords. Is before court number 5, my lords, presently.
Ask him to come.
If lordship to
Pass over.
pass over, my lords.
Ask him to.
Short pass.
On this issue, I have already delivered judgment.
My lord.
Lordship has already.
Pass over.
Item 8.
My lords, item number 8 and 9, pass over, my lords.
Pass over.
8 and 9.
Pass
Short
over.
pass. Grateful.
Item 10.
ঠিক আছে না, আমি নেই, অন্য লয়ার আছে, যাচ্ছি।
Mominur Rahman, Pritam Das. Hilol Saha Poddar,
Lordship, in this matter, we are appearing on behalf of the opposite party, Lordship.
opposite party.
Yes, Lordship. Last question, the petitioners did not represent, Lordship.
Have you informed other side?
Yes, Lordship, I informed verbally, Lordship.
Why?
But the Lordship, we have also sent a notice to the petitioner advocate, Lordship, but
Twice occasion this court directed you to intimate the petitioner. You did not intimate.
Lordship did it, Lordship, but the intimation received, I
They are
don't
not
have right now,
interested.
Lordship.
They are not interested. Earlier, the CO was dismissed. Thereafter, it was restored. What is the matter about?
Lordship, I don't have a file, Lordship. I'm not aware of this fact, Lordship.
You are the opposite party.
Yes, Lordship. Last question I appeared, Lordship, on behalf of the opposite parties.
How did you appear? Without serving?
Lordship, my senior is appearing, Lordship. Mohini Rahman is appearing in this matter, Lordship. And now he is out of station, Lordship, medical emergency, Lordship. Then, Lordship, next circuit, Lordship.
All matter placed before the next circuit. Again, next circuit, again you will pray for next circuit.
Lordship, earlier question, we don't have to pay for time, Lordship. The petitioner have taken for time, Lordship.
This is a very simple case. You intimate other side
Lordship,
by writing.
Lordship.
Twice occasion direction was passed. This is the third occasion.
Item 11.
ইনপুট এসছে এটাই তো This is disposed of. Both side?
My lord, Mr.
Item
Ghosh is
7.
already here, my lord.
Item 7.
Okay, I think this issue has already been dealt by this.
Yes, yes,
court.
yes. Well, I've seen the
And
order.
you have seen that order?
Yes.
Hearing concluded, CAB.
Grateful, my lord.
7, item number 7.
Item number 7. Hai.
Similar order will be passed.
Yes, sir.
Hai. Grateful, my lord.
Item 12.
My lord, I am on behalf of the respondent.
Who is appearing for the petitioner?
Vivek Tarafdar.
Already all further proceeding of the title suit has been stayed.
My lord, here is the appeal was filed, title suit was dismissed. Later on, appeal was filed, and in the meantime, the petition made for additional, submitting the additional
Who is the other side?
document.
Who is appearing for the petitioner? Saurav Ganguly, Vivek Tarafdar, Gopal Roy, Rishita Chakravarti. Nobody is here. None appears on behalf of the petitioner.
Thirteen.
My lord, it is against the rejection of amendment petition, the
Rejection of
amendment petition.
amendment petition.
Now, on the last occasion, we have sent the notice,
Uh,
but the notice has not yet been served. A delivery report that is there, that is in the transit showing. One is served, but others are in the transit.
Okay, you file one affidavit on the next day.
Item 14.
Yeah, the other side
Please,
is
my lords.
present.
Yes, I appear on behalf of State Bank of India, my lords.
Yeah,
Defend more one and
copy of-
Lordship has received.
My lord, this is the civil divisional application challenging the order passed by the learned Debts Recovery Tribunal Shiliguri in an interlocutory application which was filed by me challenging the order of the learned District Magistrate Uttar Dinajpur passed under section 14 of the SURFACE Act. As per the SURFACE Act, the secured creditor bank, after classification of the account non-performing asset, the secured creditor bank can enforce the Securitization Act, that is SURFACE Act. They have to issue notice under section 13(2) first, demand notice, that is the demand notice giving 60 days time for repayment. In the meantime, if the borrower or the guarantor has any represent, they can make representation. There, after 60 days, the bank can take possession. There are two types of possession. Bank can directly take physical possession or symbolic possession by their own force, or bank can approach before the district magistrate under section 14 to take for giving assistance of police for taking physical possession. In such a provision, under section 14, bank has to file an application along with the 9 points affidavit by the authorized officer. And that has to be decided by the concerned magistrate, either district magistrate or chief judicial magistrate, whoever may be, that he has to consider this application after being satisfied himself that the 9 points affidavit is there and all the compliance has been made. Thereafter, he can pass order and can take physical possession by his own, or can take physical possession by appointing his subordinate officer like SDO, BDO, or in case of CJM, he can appoint ACJM also, or advocate commissioner. Nowadays, settled principle of advocate can be as a receiver appointed. Then he can take physical possession. Thereafter, who has take physical possession, he will deliver the physical possession and the relating documents thereto to the secured creditor. This is the provision of law, Lordship. This is a settled law. So now, three position, bank has to file application along with the 9 points affidavit.
First of all, NPA, there should be
NPA, that is the one part. I am challenging the
13
to
13 14.
14, Lordship. Under section 14, the order was passed. I have challenged before the district, before the DRT in my pending suit, that is the SURFACE section 17 application. I have filed the interlocutory application. Court has taken, heard the matter. When the bank has filed the objection, on the same day, court heard the matter without giving an opportunity to me to peruse the opposition filed by the bank, not even granted any time to file reply thereto. On the 12th of March, he has closed the hearing and thereafter fixed the matter for judgment. Accordingly, 26th March, he has passed the judgment, DRT.
Did you pray for any filing reply?
Yes.
Before the DRT?
Yes.
From the order itself?
Yes,
you
itself.
can show.
That is why Justice Bhattacharya seen everything and observed that violation of natural justice is there. That is why he entertained this application without going into
merits.
And passed an interim order, Lordship. This is an interim order exists, Lordship.
Already there.
Yes, Lordship. Kindly see 17th June order passed by Justice Bhattacharya.
Stay
Lordship.
Stay was granted.
Stay was granted, Lordship. The status quo was granted because after filing my CO, Lordship, bank was, I have filed this CO.
Status quo with regard to the possession.
Yes, Lordship. Candidly, I submit, Lordship, I have filed this CO before the principal bench. Justice Om Narayan Rai had taken the hearing. He has passed some order directing me to serve the copy.
Thereafter, it was transferred here.
Lordship, 15th of May, it was taken. But suddenly, on 18th of May, matter came up under the list to be mentioned. Again, Justice Rai observed that it is misjurisdiction. It has to be decided by the before this bench. Lordship, it was transferred. Justice Bhattacharya on 17th June admitted this motion, and Lordship thereafter passed the order. But Lordship, on to be mentioned, on the date of to be mentioned, bank appeared. So it was well known under the bank, the CO is pending. Despite the same, 18th of May, matter was came up under the hearing to be mentioned. On 4th of June, they have taken physical possession. That is why Justice Bhattacharya was passing the order to set aside or stay the order of the DM, but because they have already taken physical possession, so he has passed the order for status quo, Lordship.
Status quo, not status quo, that would be abide by the result of.
And
the-
status quo, last paragraph, Lordship, can you see?
We mentioned
17th June
status
Yes, sir, there is a order of status quo. There is a order of.
Last
status quo.
paragraph, Lordship,
Yes,
can you
yes, I
see?
have seen.
So the
Now
person,
the only question is whether you have been given opportunity of filing reply or other principle of natural justice.
that is
was
also,
violated on.
apart from that, Lordship,
And your.
the
ground-
Justice Bhattacharya observed that there is clear violation of passing the order under section 14 by the district magistrate, because, Lordship, kindly
The
see.
order was passed by the district magistrate or
No,
judicial
district magistrate passed the order
District
without recording his satisfaction.
Where is that order?
Lordship, I am coming to that, Lordship. Without recording his satisfaction and empowered the secured creditor bank to take physical possession with assistance of the police.
That
This is not the settled
provision.
law.
It is not. the-
DM can take physical possession or he can appoint his subordinate officer. Now, Lordship, kindly come to page number 41 once. The order of the district magistrate. Very cryptic order passed, 5 lines order, Lordship. Nothing reflected whether the bank filed the affidavit, 9.7 mandatory affidavit or not, whether he has perused or not, nothing reflected. And not going into the satisfaction. He has not recorded his satisfaction even. Lordship, may I read this order once? Whereas the authorized officer, State Bank of India, such and such, Shiliguri, applied before the district magistrate Uttar Dinajpur for taking possession of the secured assets as noted below under section 14 of the Surface Act. First paragraph. Second paragraph, whereas the secured asset is within the jurisdiction of the DM Dinajpur, whereas the secured creditor is duly issued under section 13(2) Surface notice, duly received by the borrower, then whereas the amount due is 20% above the principal amount, that is. Next, whereas as per guidelines as stated above, the district magistrate is not required to issue any notice to the borrower or any other person at the time of hearing of the application filed under section 14. It is the settled law that is not required any hearing, Lordship. But in my case, DM issued the notice to me, come to an hearing, Lordship. I have joined the hearing. Hearing was taken by the ADM and order passed by the DM. Now, Lordship, coming to that. Therefore, thus.
Can you show the notice issued by the ADM?
Yes, everything I can show. Just page number 40. Notice issued by the DM for a hearing before the ADM. Lordship, kindly see the, may I read once the notice, contention of the notice?
Yes,
In pursuance of above mentioned subject and reliance, a notice is hereby issued for hearing against solemn order dated such and such passed by the Honorable. Lordship, in such a case, Lordship, I have to submit it. DM was delayed in passing the order, Lordship.
That's why you have filed an
No,
application.
it
for
was
the-
delayed in passing the order under section 14. Bank go before the Honorable High Court. Justice passed the order for expeditious hearing. That is the order reflection. Dated 23rd 12/2025, passed by the Honorable Justice in connection with the High Court case number such and such in the matter of State Bank of India and State versus State of West Bengal and others for taking possession of the secured asset under section 14 of the Surface Act 2002 will be held at the office chamber of the Additional District Magistrate General Uttar Dinajpur on 16 January 2026 at 12 p.m. 12 noon.
That is the office, but it.
No,
was-
Lordship, that
it was
hearing,
Issued by the district magistrate.
Exactly.
this notice was issued by the DM.
The
But
notice was
hearing was conducted by the ADM. I have appeared before my junior was appeared before this ADM.
Where from reflection in
That
the
is not
order,
reflected any order.
order has been passed by DM.
Order passed by the
Notice
DM,
was
Lordship.
issued by the
But
DM,
the,
only office.
Lordship,
Office,
the hearing was taken up by the ADM, Lordship.
ADM.
ADM. I have specifically named his ADM
Did you
in my
file-
petition.
Did you file any, your
Objection
Hajira-
before.
Hajira before the,
Yes. The usual process is that the signature has to be done. My junior has endorsed his signature.
okay, whatever maybe he has
Lordship,
passed.
now that is one part. And now, Lordship, kindly come to page number 41, the last paragraph I am reading. Therefore, the Superintendent of Police of Raiganj Police District, Uttar Dinajpur is requested to provide police assistance to the secured creditor for taking possession of the secured asset as noted before, noted above.
So the
So,
power
Lordship,
has been given to the secured creditor to take the possession.
that is one
with
part.
the help of the
He has
police.
not recorded his satisfaction. Nothing has been given. Lordship, I have challenged this.
He has recorded the grounds. Many grounds has been.
No,
recorded.
Lordship,
Where
9
are-
points. Lordship, if your Lordship kindly come to now, I am reading once the provisions of law, Lordship, that is section 14. If you look, it is surface একটা দেবেন, surface.
এই যে,
Lordship, section 14.
Yes.
Section 14(1), Lordship, where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured assets is required to be sold or transferred by the secured creditor under the provisions of this act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the chief metropolitan magistrate or the district magistrate within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the chief metropolitan magistrate or the case may be the district magistrate shall, on such request being made to him, take possession of such asset and documents relating thereto, and forward such asset and document to the secured creditor. This is the first part, Lordship. So DM can take physical possession only. Thereafter, Lordship, first proviso provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor declaring that there are 9 points at there, Lordship. The first point is aggregate of financial assistance given, what is the claim on the date of application. Then there are 9 points, Lordship. I'm not reading all these 9 points, but that has to be mentioned in their 9 points affidavit by the file by the authorized officer of the secured creditor bank. Then, Lordship, coming to the next proviso, provided further that on receipt of the affidavit from the authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose for taking possession of the secured asset within a period of 30 days. That is another part. So he has to record his satisfaction. Next proviso, Lordship, that I'm leaving the next proviso, that is a time limit,
60 days.
60 days, Lordship. Next proviso, provided also that the requirement of filing affidavit stated in the first proviso shall not apply to, no, Lordship, kindly come to section 14(1)(a). The district magistrate or the chief metropolitan magistrate may authorize any officer subordinate to him to take possession of such asset and documents relating thereto, and to forward such asset and document to the secured creditor. So, Lordship, he has to record his satisfaction, then he can appoint his subordinate officer, not the
14(1)(a) one specific said that by him or subsequently 1(a) amended or inserted.
Absolutely, Lordship.
Asserted
By the
that
subordinate
he
officer.
may appoint any or authorize any subordinate to him.
Act, exactly, Lordship. Exactly.
This is
Lordship,
the-
now, Lordship, I am relying 2-3 judgments of the Honorable Apex Court, as well as in our High Court. Those judgments are very celebrated, Lordship, passed by the Honorable Apex. I am coming to the first judgment. That is,
Why you have come before this court by way of, there is no provision of appeal with regard to the.
Lordship,
that would be under section
Lordship,
18.
kindly see, Lordship, 17 June order passed by the Honorable Justice Bhattacharya. I am reading the first
My
paragraph.
question is whether that order.
The
is
maintainability
not-
question,
not
Lordship, I have
applicable.
satisfied before the Honorable Justice Bhattacharya the question of maintainability, and he has recorded that in view of prima facie palpable abuse,
Which
17 June
paragraph?
order.
Which paragraph?
First paragraph, Lordship.
First paragraph.
17 June
View of
order
prima
passed by the
facie.
Justice Bhattacharya. In view of the prima facie palpable abuse of the process of court and violation of natural justice vitiating the impugned order, the present application under Article 227 of the Constitution of India is entertained, despite the availability of an alternative remedy by way of challenge before the Deputy Regulator. So this question was, I have satisfied before this court. So, Lordship, there was a violation of natural justice, and Lordship, kindly come to paragraph number 4 once. Paragraph 4. The learned advocate for the petitioners also raises a foundational question as to whether the order under section 14 of the Surface Act passed by the district magistrate, which has been assailed before the tribunal, also suffers from parent lack of jurisdiction in view of magistrate having failed to record satisfaction regarding the mandatory parameters to be satisfied by the bank by way of 9 points affidavit as required under the said provision. So all these points is open, Lordship, except the maintainability. Lordship, now I am citing one judgment, relying on judgment, Lordship, passed by the Honorable Apex Court, Lordship. The very celebrated judgment, Lordship, Standard Chartered Bank versus Nobel Kumar. Lordship, kindly come to paragraph number, paragraph 25 once. Paragraph 25, Lordship.
Yes, 20.
May I read, Lordship? The satisfaction of the magistrate contemplated under the second proviso of section 14 subsection 1 necessarily requires the magistrate to examine the factual correctness of the assertion made in such an affidavit, but not the legal niceties of the transaction. It is only after recording of his satisfaction the magistrate can pass appropriate orders regarding taking of possession of the secured asset. This is observation by the Honorable Apex Court. Now I am coming to Lordship, our High Court judgment. This is also a celebrated judgment passed in judgment. Lordship, this is Krishna Builders. Lordship, passed in Krishna Builders versus Sridhar Housing Finance Limited. Our judgment, our High Court judgment, Lordship, paragraph 61. Lordship, paragraph 61, Lordship. Lordship, got it? Lordship, may I read, Lordship? In regard to
61.
satisfaction,
1
this,
minute. 61. Yes, 61.
this is regarding satisfaction, Lordship. As regards the 9-point satisfaction, it is not reflected even in a single sentence of the district magistrate order that the district magistrate was satisfied with such 9 points having been mentioned in the affidavit filed by the secured creditor. The specific language of the second proviso to section 14 of the Act is that the magistrate shall, after satisfying the contents of the affidavit, pass suitable orders in the absence of any reflection of such as in the absence of any reflection of such satisfaction, the order under section 14 is vitiated ex specie. Although no detailed inquiry as to the veracity of such 9 points was perhaps required under the law, the magistrate was duty bound to record a satisfaction as to such points being mentioned in the affidavit. The purported reason in the order of the magistrate were entirely alien to a consideration under section 14 and as such stood vitiated. So this is a settled principle of law, Lordship. DM has to record his satisfaction first. Then, Lordship, my next point is that the authorization to the secured creditor for taking physical possession. In this regard, Lordship, our High Court passed one judgment in, Lordship, Justice, Honorable Justice Dipankar Datta passed this judgment. Lordship, Pratima Roy versus Union of India, Lordship. Justice, Honorable Justice Dipankar Datta passed this judgment when he was sitting in Calcutta High Court, Lordship. Lordship, from first page, last line. Mr. Shamanto, learned advocate for the petitioners, refers to section 14 of the Act. According to him, the district magistrate is empowered on a request made by the secured creditor to take possession of the secured asset and the documents relating thereto, and thereafter to forward such asset and document to the secured creditor. However, the district magistrate cannot abdicate his duty of taking possession and direct the superintendent to provide police force to the secured creditor to take over the possession of the secured asset.
Similar issue.
Similar issue, Lordship. And it was decided long back. Thereafter, Justice Devanshu Bashag was passed an order, Lordship, in Shasta and Agro Industries Limited, Industries and another versus Union of India. Same line, Lordship. The secured creditor cannot take physical possession under section 14. Either DM himself or any other subordinate officer to that DM.
I think the word shall is used, no? Shall. Shall is used.
No. When, Lordship, the authorization, in case of authorization. Section 14.
District magistrate shall on such request being made to him take possession. Shall.
So
And may authorize anyone.
authorization may.
That is subordinate to him.
It is amended, Lordship. It is thereafter
It is
inside.
not that the secured creditor is subordinate to the deal.
Yes, Lordship. Several judgments, Lordship, there. Now, to convenient for the
Any
DM,
other judgment you are relying?
for the convenient of the DM, Lordship, nowadays, it is also passed by the Honorable Apex that DM can appoint the advocate commissioner also.
Commissioner also.
But in my case, secured creditor will take physical possession with the assistance of the absolutely bad order, Lordship, satisfaction recorded. That is why Justice Bhattacharya entertained my application, Lordship. Lordship, kindly see this order passed by the Honorable Justice Devanshu Bashak. Lordship, there are no page number in this, Lordship,
No
and
problem,
paragraph
this
also.
paragraph you just-
Lordship, page number 4. Page number 4, Lordships, the paragraph 4, Lordship. The start with, in my view, I have given, Lordship. Pastaya Nagara, Lordship, I have given.
Devanshu Basak, yes, yes. Which, second page?
4th page, 4th paragraph, Lordship. Start with, in my view.
Which paragraph? Paragraph, which first page?
Second,
Second
4th page, Lordship.
Third page? Where in Pratima Roy?
No, Lordship, I have given a judgment. Pastaya Nagara, Lordship.
Uh-huh.
The 4th paragraph starts with,
Paragraph.
in my view. Lordship, may I,
In my view.
in my view.
First, second.
In my view,
Fourth paragraph.
yes, Lordship. 4th paragraph, Lordship. In my view, the district magistrate acted in excess of jurisdiction vested upon him in law by Section 14 of the Surface Act 2002. Section 14 of the Surface Act 2002, before the introduction of subsection 1A, they had to require the district magistrate on a request of a secured creditor for assistance to what Lordship says, Lordship. Before amendment, it was the duty of the district magistrate to take possession himself, or and thereafter he will forward the possession to the secured creditor. Lordship, now in the instant case, the district magistrate Bakura did not do so. The district magistrate took no steps to take possession of the secured asset and documents, and thereafter forward such secured asset and documents to the secured creditor by himself. The entire proceedings of the district magistrate culminating into the memo bearing number such and such, dated such and such, emanated from the request dated February 15, 2012 of the bank. The entire proceedings, in my view, were vitiated. The request of the bank to the district magistrate contained in the bank's letter dated such and such was beyond the power granted to a district magistrate under Section 14 of the Surface Act 2002. By the memo such and such, dated such and such, the district magistrate proceeded to permit branch manager of the bank to take possession of the, with the assistance of police and the block land and land reform officer Patrashayar. This was again beyond the mandate of Section 14 of the Surface Act 2002. Section 14 of the Surface Act 2002 permitted a district magistrate to take possession of the secured asset and documents by himself. He could not, purporting to act under Section 14 of the Surface Act 2002, direct police assistance to the branch manager to take possession thereof. The memo was therefore in excess of the powers vested in the district magistrate under Section 14 of the Surface Act 2002. So, Lordship, all of these judgment says the district magistrate cannot authorize the direction to the police to assist the secured creditor to physical possession, and satisfaction not recorded, Lordship. ADM took take the hearing, DM passed the order. So, Lordship, this order was absolutely bad. I have challenged this order before the learned DRT Shiliguri, and he has recorded all my submissions. Firstly, violation of natural justice, because on the date of serving the copy, Lordship, kindly see page number 76 once of my CO.
This number?
76. This is the order dated 12th of March, Lordship, when the matter was taken for hearing. Counsel for the applicants, my name. Counsel for the respondents, Mr. Chakraborty was appeared. Heard the learned counsels of both the parties on IA number such and such, and before that, Lordship, kindly take note, before that, the learned counsel of the bank files objection and serves the copy to the counsel of the applicant. On the same day, he has filed, and served the copy. Leased the matter on 26th March for passing the order. On that day, Lordship, the hearing was concluded and orders accordingly 26th March, the impugned order was passed. In the impugned order, Lordship, he has recorded in my submission, kindly come to paragraph number, page number 3, paragraph number 5. He has recorded my plea. In the instant IA, the applicants have taken together 3 pleas, out of which first plea of the applicants is that the learned district magistrate did not record his satisfaction regarding the 9 points affidavit. Second plea of the applicants is
Please
that
show me where you have pointed out that you want to file written objection.
Lordship, that is absolutely not recorded, but that is true, Lordship. I have prayed that my Lord, Lordship, before the learned court for giving a chance to file reply as well as to peruse the opposition.
That was not allowed.
Not Lordship. He has served me on the same day, hearing concluded. And Lordship, interestingly, my entire allegation against that bank did not file the 9 points affidavit because from the order of the district magistrate, it is not reflected that whether the bank was.
You have filed the objection, written objection in paragraph number 3.
Lordship.
Respondent filed their written objection stating that present IA, however, been signed by and affirmed by so and so.
Paragraph number 3.
Oh, that was the written objection filed by the bank.
Yes. Written objection filed by the bank on the same day of hearing. I was not given an opportunity to peruse the same and hearing.
File or reply either.
That is the clear violation of natural justice, Lordship. That is why my application is entertained by the Honorable Justice Bhattacharya. Lordship, kindly see my specific prayer pleadings were there. If your Lordship kindly come to my IA, page 46 of my CO. This is the copy of my IA which was filed before the
46.
46, Lordship. Page 43 starts from my IA.
All those points you have raised.
Lordship. Kindly
Whatever-
see, Lordship. Interestingly, paragraph number 10. I have made the specific plea. In the other words, said order passed by the district magistrate Uttar Dinajpur, section 14 of the Surface Act is mechanically pronounced and or cryptically made. In light of the said fact, the defendant bank is called for to disclose the affidavit filed before the district magistrate. Before obtaining the said order under challenge, the applicants reserve the right to take supplemental grounds to challenge as and when the said affidavit is produced by the dependent financial institutions. That was my specific pleadings. But despite the same, bank has filed their opposition without enclosing the 9 points affidavit.
So you want to file a reply before the
Lordship,
DRT.
absolutely bad order passed by the learned DM, Lordship, the district magistrate Uttar Dinajpur. That order should be quashed. That order should be quashed, Lordship, because
That should be heard by the DRT.
Lordship,
giving an
DRT hard,
opportunity-
DRT hard,
Giving an opportunity of file the reply.
Lordship,
Besides the
DRT
press.
hard,
My lord, my learned senior may kindly complete.
DRT hard, Lordship, page number
No,
3,
DRT hard without.
not observe everything.
Without giving any opportunity of.
Yes, that is true, that is true, that is true. And
Perusal of the
without,
objection and filing reply.
he has recorded,
That should be filed, then it should not be here. It should
Lordship, he has recorded my plea. He has, but not recorded his observation regarding my plea about satisfaction. He jumped to the point of
You have come here only regarding not given any opportunity of hearing.
as well as
or-
for setting aside of the order of the DM, Lordship. Both my prayer.
If you
Lordship,
make a prayer.
if your Lordship,
both prayer,
if your Lordship,
then
no, that
whether-
was the ground. That was
whether
the,
this court has jurisdiction to entertain that
no, Lordship,
in CO.
no, Lordship,
If
the
any order.
CO is
being
maintainable,
challenged,
it's
if you
entertainable
want
because
to
of
challenge any impugned order passed by the DRT, that should be appealable order.
appealable order. That is true, Lordship. That is true. That is true. But Lordship, when the court is, Honorable Court is seen that the initial order passed by the DM is absolutely bad, apparently, the court has the jurisdiction, Lordship. Court has the ample power, Lordship, court has the
Anything
jurisdiction. Even what judgments I have relied, Krishna Builders, that is the case. In sitting revisional jurisdiction or determination, Justice Bhattacharya set aside this order. of DM also.
Where is that order?
Krishna Builders, Lordship, I have.
Krishna Builder also.
Yes, Lordship.
Oh, Krishna Builder directly DM order has been set
Quast,
aside by
quast,
the
quast, quast.
High Court
Yes, Lordship.
in CO.
In CO, Lordship.
Oh, in CO.
Lordship, Honorable High Court has the ample power under Article 227. So,
Because he exceeds his jurisdiction and passed the order.
yes. Yes, Lordship.
Yeah.
Yeah, my lords. On the very face of record, my lords, the respective petitioners may look like cabbage, my lord, but unfortunately they are not that green. And I'll point it out para-wise. Kindly see the fallacy, lordships. What my learned senior said on behalf of the petitioners. My lords, the learned DRT presiding officer has recorded everything. He has candidly submitted that at first. Then again, when it comes to the impugn order and the order before it, it was categorically not filed for a reason. Because since he has said the Honorable DRT has considered everything, recorded everything, then passed the impugn order, that means the very submission was not made that I need to file a reply. And this is nothing but a forum shopping. It is just another feeble attempt. I'll just try to guide my lords through as much as I possible. Lordships may kindly see the very page number 76, top of the heading, my lord will find the very case number. This is very important. SS, my lords may kindly.
76, yes.
Yes, sir. After page 76, in my copy, there is no pagination, but that should suffice.
IA case number
IA case numbers 177, 2006, my lord, in essay 71 of 2023, my lords. Now, my lords, may kindly to the Surfacey book, if it is 2026 edition, my lord, that would be in page number 32 of the book, the section 17.5. Kindly see. Kindly see.
17.5.
Yes, sir. Any application made under subsection 1 shall be dealt with by the Debt Recovery Tribunal as expeditiously as possible and disposed of within 60 days from the date of such application, lords. Now, the Surfacey application per se dates back to 2023. And my lords, kindly see to the CO at page number 3. Kindly see to the page number 3 of the CO.
CO.
Yes, sir. Application is valued at, my lords, rupees 6,64,52,535. That is the public money. Bank is nothing but a custodian of the public money, my lords. This is nothing personal. Nothing against the officer.
Question is not
My lords, I will answer each and every question one by one.
Here is the question of statutory mandatory
Exactly. I am coming to that.
was followed or not.
Exactly. Now, this very CO itself, my lords, it is being hit by the principle of generally specialibus non-derogate, my lord knows. There is a special law, it supersedes everything else. This is badly hit by the principle. Generally specialibus non-derogate is the law. Now, kindly come to the section 18, my lords. This is a completely appealable order. This is my humble submission before the court. All the justice has indeed did not went to the merit and has recorded his view, but this honorable court has the full authority to decide the merit of its own. Now, section 18, appeal to the appellate tribunal. Subsection 1, any person aggrieved by any order made by the Debt Recovery Tribunal under section 17 may prefer an appeal along with such fee as may be prescribed to an appellate tribunal within 30 days from the date of receipt of the order of the Debt Recovery Tribunal. Now, my lords, here such fee, that word such fee is very important, and I should assist my lords in deciding that. Since my learned senior friend has been representing the respective clients and the petitioner in the present application in the various courts of law, my lords, I am not handing over a copy, but my learned's name itself is appearing. So this is a copy of the order dated CO 1340/2026, my lords. Kindly see. তোমাদেরই order last. Brindaban Rice Mills versus State Bank of India. Yes, sir. Your name is only appearing. It is there. 3 number. Yes. হ্যাঁ তো তুমি না কে করেছে? Kindly allow me to submit, sir. Yes, yes, fine. Why not? Please.
Now it is transferred and numbered as SCO 82.
Of course. Who is disputing? Now, my lord, kindly see. Admittedly, this matter was heard by the Honorable High Court at Kolkata, and without going into the merits, that is my exactly point. Without going into the merits, the matter was transferred. Now, my second submission before the court is the order of CO 3556 of 2025.
What is the wrong of this order?
Nothing. I just put this on record. Kindly see. AJ, Ranjan Kumar Paul, this is your name, sir.
Because this order has been passed.
No. Sir, how can this be, my lord? I did not utter a word for 15 minutes, my lord. Within 30 seconds, if my lord senior interrupts in this way, how can I?
No, this order is only transferred the.
I relate to one by one, my lord. Kindly see.
From the.
Kindly see the
persons
orders.
To Jalpaiguri because the jurisdiction of.
Yes, of course. My lord is correct.
Secured credit.
Kindly see. Now, my
and
lords,
the
may kindly
property-
see the headline of this order, my lords. CO 3556 of 2025. Ranjan Kumar Paul versus State Bank of India. This is very interesting. Who is this Ranjan Kumar Paul? My lords will find the answer at page number
to
2.
prejudice this court.
No.
This
How
is relating
come?
to another account.
No.
Person can
The person is
maintain
same.
several
No.
accounts with
Sir,
the SBI.
How can? Let me complete, sir.
We are.
No, let
we
me
are with
complete.
the
This is nothing but a
I'll speak.
feeble attempt. This is nothing but a
Another
feeble
loan
attempt.
account, another
No.
case.
Whatever the case may be. This person is the key person.
No. This order is with regard to the SA number 126.
Yes,
Of course. No, my lord. I want to portray the intent of the person, my lord.
SA 71.
My lord, it is the suppression.
What is related with this?
My lord, just I'm yet to complete. Give me 30 seconds, not more than that. 30 seconds shall suffice. Kindly see. Now, who is this person, Mr. Ranjan Kumar Paul? Kindly see to the page number 2, my lords. He is the present applicant, and the page number 13, he has signed the
What do you want
affidavit.
to show from this order?
Yes.
He is the defaulter.
No. He is also a defaulter in this matter, my lords. And the kind of.
He may be a defaulter of 20 cases.
Yes.
That is.
Of
not the
course.
subject
Of course.
matter.
No. But
That is not the
why
subject matter.
why I submitted before
Here
is.
subject matter is whether this
Of course.
original application
Of course.
is maintainable.
Exactly.
Whether appeal can be filed against that order.
Yes, sir.
Number
Yes, sir.
one. Number
Just give me
two,
30 seconds, my lord. Not more than that. 30 seconds.
37. Why I will give you 5 minutes.
Fantastic. Now, my lords,
Yeah.
kindly see in the very order that kindly see to the operative portion, my lords. Paragraph number 4. Kindly see. Nothing against the advocate. It is against the client only. Nothing against the advocate. Kindly see to the paragraph number 4. Any order passed by the Debt Recovery Tribunal is an appealable order. A coordinator of this bank court admit the revisional application by conscious of such provision only on the ground the appellate tribunal would remain closed for some time. Thus, a limited interim order was passed, restraining the opposite party from taking coercive actions. Order dated 8 October 1st, 2024, passed by the district magistrate, Dakshin Dinajpur. In that matter also, a section 14 order was challenged. The occasion entered the revision application has since outlived the reason the appellate tribunal is functional. Thus, the petitioner shall prefer an appeal. Now, the High Court has made a view. Thereafter, here comes the interesting part. Kindly see, this is the order of the Honorable. No. Sir,
This is a different matter, Lordship. In
sir,
that
let
matter,
me-
we have
let me-
already
let me
preferred
try
appeal.
to convince the
After
court.
passing
No,
the order,
why
we
are
have
you
preferred
objecting
appeal.
in middle of my submission,
We have-
sir? Allow me to submit. I'm here before the court.
He is trying
No,
to
I am
submit
here
another
before
matter
the
in this
court.
matter to
You are
prejudice
going
this
to
court,
give the reply, sir.
Don't
You are-
shout, sir.
So,
Don't
sir,
shout.
this is
Appeal also
kindly,
can
kindly.
hear
See, I'm
and-
trying to.
And court will also
I'm-
can hear. your
My lord,
point.
I fail to understand, my lord. I did not interrupt for a moment. I did not interrupt.
Why
At least that much. That should have been appreciated by my learned senior. I did not utter a word.
No, your contention, I understood that this CO is not maintainable.
Not only that.
Appeal will be maintainable.
Not only that. No, there is more to it. There is more to it.
Yes.
Kindly see the order passed by the Honorable Justice Anil Kumar Srivastava in the DRH matter, my lord. That is before his lordship. And the last portion. Kindly see.
Kindly ask
No,
me
kindly-
one question. whether all these
Kindly
has
see,
been
I will,
connected to this matter.
I will connect,
no?
I will connect, I
Kindly
will
ask
connect to
him
the
one
intention.
question.
Let the court ask the question, sir. Why are you suggesting the court? Why are you
Lordship
suggesting the court,
rightly
sir?
observed that he may be defaulted in
Sir,
70
please.
accounts.
No. This is very
No,
important.
he's showing that the.
Everything connects, my lord.
CEO has been disposed of, contending there in that the appeal is maintainable, CEO is not maintainable.
That is
No,
in
there
another
is a
case.
reason, my
That
lord,
is
that
in
is
another
not the,
case.
my lord, at first place I said, they may look like cabbage, they are not that green. I will put an effort to it. I'll prove it right now. Kindly come to the last portion of the respective paragraph, my lord. That is a page number 2, order dated.
Passed by Anil Kumar Srivastava.
Yes, sir. Yes, sir. Kindly come to the page number 2. Law is going from the last paragraph of the first page.
First page, first
Yes,
page.
sir. The last paragraph. Law is well settled that appellant is required to make pre-deposit of 50%, which my lord has already gone through under section 18 of the date due on the date of filing appeal. Amount deposited by the appellant after the issuance of section 13(2) notice has already been adjusted. Auction sale is under challenge. Hence, the appellant cannot take the advantage of the sale proceeds. However, date on the date of filing the appeal 12/12/2025 is rupees 2,67,26,342 and 25% remains to be payable as per the order of the Honorable DRT. 25% of 2,67 lakhs is, my lord, 67 lakhs 81,000 amounts. Say 67 lakh rupees. This CEO, the present one in our consideration, is nothing but a feeble attempt to eyewash of the court.
Yes.
They know if they go for an appeal, first they will have to pre-deposit. First they have to pre-deposit. Then they stop. I am not entirely sure. They might not have the money, my lords. This present CEO is nothing but a feeble attempt. That is how it is connected. That is why I relied on all three. This is not the ignorance of law. He knows the consequences.
A person cannot.
Of course.
Right to file reply.
No, not at all. Now, my lords, I am coming to the respective judgments, my lords.
No, I'm asking you whether you are not entitled for submission.
Anytime, my lords. But it is the discretion of the court to entertain. It is the discretion of the court to entertain the submission, my lords.
Suppose you ask for reply and I will not consider your submission and I will decide.
But
I will not given you hearing of opportunity.
What has fallen
And
from, my
I'll
lords,
pass
is
the-
absolutely correct. But then again, then also it goes against the observation made by learned senior.
Bottom is always there.
Of course. There is no doubt about it.
So in CEO superintending power is High Court.
Of course. There is no doubt.
So only on that point, that order cannot be set aside.
Not at all, my lords. Whatever fallen from his lordship, absolutely correct. But there is a but to it. There is a little if. What my learned seniors begin with, everything was recorded by the DRT, but the order was not passed. Whether he has annexed the order for my lord's consideration, passing the DRT at that time.
What is the difficulties in granting one opportunity to the party? To
Only-
file objection, written objection, same day.
No, my
Not
lords,
prompted.
no, he has not placed the order sheets, my lords. I have not filed the written objection on the same day. If I have received something, I could not prepare the opposition in 7 days. I have received it at 26.
When you have
I
filed
took
objection,
two date time.
from the order itself, it is appears that the objection filed by you on that day and hearing concluded and order passed.
No, my lords,
Why
that
principal-
is not the entire truth. There was another hearing on 5th of March 2026, my lords.
Place that.
My lords,
Lordship,
I
give
will,
me an opportunity, Lordship. I am telling you the fact.
sir, I was in
When-
middle of something.
One second.
No, I was middle of
Record
something.
will speak.
Yes.
Record will speak.
Yes,
When
Lordship.
he has not placed the entire record.
Lordship, kindly see now.
It is
that
his application, my lords. How can
I
the
do not
hard truth
want
is
to
spoken?
utter these words, Lordship. Lordship, kindly
Then
see.
how come the
When
hard
I have
record is
served
spoken?
this application to the bank prior to 15 days of the hearing, that is 5th of March, right? On 5th of March, bank came. I have served the
My
copy.
lords must be supplied with a copy of the
Yes,
order.
sir. I have
Then
served
kindly
the-
pass it over, my
I have
lords. Let us
served the
print it
copy
out.
15 days prior on 5th,
No, I am asking only objection, when the objection was filed.
on
and
12th
when
of March.
served.
On the 12th, on 12th of March. That is
And it
reflecting
was
from
served
the,
on same
on
day.
the same date. Lordship, he is referring the others order, in this case, the previous
I am
order.
not asking about
Yes.
other.
Kindly
In
see that.
this case, your IA application has been filed.
Yes, I have
Again,
served the copy.
again.
After 15 days matter came up for hearing, he sought
Fine.
time. He sought time on 5th.
Where is the record?
Kindly, That is from the 5th of March order.
And that is
He
what?
sought time for objection. Lordship,
Now he is making
the
the truth, my lord.
situation was that.
Now he is saying on
Lordship,
5th of March, I thought
Lordship,
time.
Place your
Lordship, the
Yes, yes,
situation,
yes, of course.
the situation was that he sought for time for opposition. I prayed for interim order. Court says, no, there is not required of interim order because he said, I am undertaking,
Yes.
I will file my opposition within 2 days.
Yes.
Within 2 days, there is no requirement of interim order. Accordingly, court fixed the matter after 7 days, recording his undertaking.
But I have soon
But
within my
within
undertaking.
2
the
days,
opposition was not
within 3
taken.
days, he has not filed the objection,
Not
not
served.
served the copy. On the date of hearings, after 7 days, he has filed the objection and served me copy, and that tribunal say, start your hearing.
This is
I was consent
this is
to
very wrong.
commence my hearing.
To say against a
Submission.
court of law that the submission was not
I will
recorded.
see, I
My
will
lords,
see
my lords,
all
my
the
lords,
orders.
absolutely,
Who is
absolutely.
right or who is wrong?
Absolutely,
I will-
absolutely,
I will find
absolutely.
out.
Copy of the 5th March order.
I don't have a printed copy. I can show you, then pass it over, my lords, I will get it printed.
Read the order, read the order.
Fine, fine, I'll read.
Read.
Let my lord direct, I'll read.
He sought time on the ground and undertake to not to take physical possession.
You have all the orders?
My lords, not printed. Then kindly pass it over for 5 minutes,
Lordship,
I'll get it
This is
printed
the
within no
fact,
time.
Lordship. This is the
Or
fact.
kindly
On
fix it
12th
tomorrow.
of March, he has filed objection and on the same day he serves copy and hearing concluded on that day.
That is the subject
That is the
matter
subject
here.
matter. He is referring the
He is
previous
saying
order.
objection was served.
Yes, on the
there.
same day, on the same
No,
day.
You are saying
That is
objection
why,
was
Lordship,
served
this
on the
motion
same-
was admitted. On the basis of this ground only, the motion was entertained.
That I have seen the order.
Yes,
of
Lordship,
the
and
court.
of course, the bank has not challenged this order of Justice Honorable Bhattacharya. Now he is opening the maintainability point.
Why to? The CEO was
By-
never
by-
served
by-
on me.
by
It is
handing
always
over
open
the-
for me to
by
challenge.
handing over
Now,
the
my
order,
lords, I was
another
not,
case.
my lords, I was not completed with the arguments, my lords. Now,
So can you file the all orders
my lords, I'll by tomorrow, my lords, I'll file.
by tomorrow?
But my lords, let my argument be completed on
Pass
the
over,
maintenance.
Lordship, kindly make it pass
Tomorrow,
over.
tomorrow,
I mean,
tomorrow.
Within 2 minutes with that
Tomorrow,
order.
tomorrow.
4 lines order.
My lords, may kindly একটুখানি সাহেব একটু কষ্ট করে দিন না
I
প্লিজ
have to return back, Lordship, today. The 5th March order.
So,
The 71.
after that 12 March 2026, where is that order?
Yeah,
That
Sir,
is-
the next order.
76.
So on that day you have filed the objection. So this court when you have solved the objection.
So on that
the
very
same
day.
On that
On-
very
on-
day.
on-
How
on-
court can hear? If suppose someone filed a affidavit in opposition today, I will not allow him to file reply or objection.
May I humbly submit?
Yes.
My lords, it was their duty to seek for an adjournment to file the rejoinder, my lords. They have not sought. They have not sought.
I
They have
was
not
consent
sought.
to start my hearing.
My lords, on the point of maintainability, a few lines, please. Why not? Now, my lords, to begin with, this is the order passed by the Honorable Supreme Court in Satyavati United Bank of India versus Satyavati Tandon, my lords. I beg my lords' attention towards the paragraph number 28, thereafter paragraph number 55. My lords may kindly see. May I pick, my lords? 28 first.
Yes, 28. No, there is a specific provision that is the appealable order.
Yes,
Now,
yes.
my question is, if suppose the DRT has not given any ample opportunity of hearing or audio ultim partem or filing reply, in that case, CO is maintainable or not?
Of course, but that remains to be seen by you.
Please show me any judgment that in that case, CO or writ petition is not maintained.
Then, my lord, no, there is no, it cannot be in existence. Literally, it cannot be in existence.
Because suppose tomorrow I will decide upon hearing him.
Yes,
You will be prejudiced.
yes, of course,
And if I not recorded anything.
of course.
From this record itself, it will appear you have served the copy of objection
Of
on
course.
the same day.
Of course.
Hearing concluded. How it is possible?
Lordship, they did
How
not seize time. It was on their part. They have not
That
made
is
the
your
submission before the court.
submission. His submission is not recorded, but
I don't know
I
how.
will see.
My lords, of course,
I will see from
Of
the
course,
record
of
that
course.
no reply.
maybe, my lords, they have not sought for time. I was there in person.
And there is a good ground for merit
Of course, there may be.
as per law.
That is as per law,
As
of course.
per law, DM order is itself is a bad or contrary to the law.
My lords, that
that
remains to be
case-
the
in
part
that
of the
case,
opposition,
this
my lord. That
matter
has to be decided.
This case should not be referred to the DRT to given an opportunity to hearing them and pass reason order.
But my lords, it is very unfortunate that in DRT, in reality, they did not take time on that. And they were fined only to a few pages of
No,
order.
from the record itself, if suppose you give a objection of 2 pages, even 1 page, why he will not get an opportunity to reply or reply?
But at least he ought to have submitted before the court.
He has submitted, if not recorded by court, then what would happen?
But he only
What
submitted,
would happen
everything was
is that
recorded.
If court would not record.
His argument by submitting the everything is recorded.
By the court, he is not preferred to file any reply or.
My lords, I fail to understand. No, I fail to understand as to how a court can record everything, then again goes
Yes,
back.
everything should be recorded. We record.
Exactly, they have not submitted. The court has not recorded.
Anything more?
Lordships, I was on the.
Only on that, my question, can you have any judgment that CO will not maintainable?
Even on the point,
Audit petition is not maintainable.
on the maintainability point only I was saying, but
I'm
not on the
asking-
point. No,
I'm
specific,
not
no,
asking about the marriage.
no, not on the specific point is but my
So
lords. No.
this should be referred to
No.
the DRT. You give him opportunity of filing reply and hear and decide the case.
Very well, my lords, if my lords think so, if that falls from the my lord, we'll certainly comply.
Please, please.
But my lords, there is a fallacy, my lords. The property admittedly has already been sold.
No, you have already taken the position.
I have handed over as well.
Handed over to whom?
To the auction purchaser, my lord. The auction has long been taken. That order is not under challenge, of course.
Auction is under challenge even before the DRT also.
DRT also, that is under challenge, but that has been decided. That they have not made him a party, my lord.
That would be subject to the result of this.
Of course, but they have not been made a party to the CO only. They are necessary party. CL certificate if they executed, that becomes a necessary party. That there is a title transfer.
The order has already been passed by the coordinate bench that the whatever position has been taken, that is subject matter.
Then, my lords, one humble submission, my lords, give me 2 days time, my lords. I will come up with simple opposition why they should be added as a party. They are necessary party, my lords.
No.
They will be prejudiced.
Who are?
The auction purchasers, my lords.
They may come before the DRT.
Yes,
They
yes.
go before the
Even I have
DRT.
made the
Why
application
you
to
are,
implement them.
Taking a plea of their.
I have already made
their
application to
plea before
implement them,
this court.
Lordship.
They may go before the DRT.
Definitely.
Ask for addition of parties.
But then again,
I've
it is
already
the
made
duty
it.
of an advocate to satisfy my lord's queries. I'll see if it is
Tomorrow,
maintainable at all.
tomorrow.
My lord, day after
I
tomorrow.
have heard you from your side. If he can satisfy, ask any junior to remain present tomorrow.
Lordship, I will appear virtually, Lordship.
You can have.
My lords, day after tomorrow, please.
No, day after tomorrow it is.
My lords, tomorrow it will be a little difficult, my lord. Day after tomorrow, my lords, or the day after tomorrow,
No,
day after.
because we have only
Then on the second half tomorrow, my lords.
tomorrow.
Second half.
Second half, I am.
Second, very well.
I am
Done.
sitting on
Yes,
second
sir.
half.
Yes, sir. Done. Second half.
Lordship, although Lordship, the maintenance limit point is not still open because
I am only concerned about CO is maintainable or not.
Lordship,
Number one. Then CO is maintainable or not, only on the point that you have not given opportunity to file reply and without giving.
that is observed by Justice Bhattacharya, Lordship. Lordship, although it is not open, still not open for them because he has not challenged that order of Justice Bhattacharya. Already the CO is entertained and
My lord, my
Already taken
limitation is
order,
late to go, my lord.
everything
I have
done.
received it
I
on
will not-
26.
still Lordship, I am
I have
reserving my
received it
judgment,
on
Lordship.
26, my lord.
Violation of natural justice. In case of violation of natural justice, CO is maintained.
I have received it on
Yes,
26.
that's why I put
Lordship,
question.
Lordship, kindly, page number 349, paragraph 49G. May I read once, Lordship? Apart from the situation pointed in E and F, High Court can, paragraph 49G, page number 349. Lordship, at the bottom, the page numbers are appearing.
49
349,
G,
49G, Lordship.
EFG, yes.
Apart from the may I read out? Apart from the situation pointed in E and F, High Court can interfere in exercise or its power of superintendence when there has been a patent perversity in the orders of the tribunals and courts subordinate to it, or where there has been a gross and manifest failure of justice or the basic principles of natural justice have been flouted.
Definitely, otherwise anyone can pass order and anyone can dispose.
Of course.
Must be there.
Lordship, I am praying for setting aside of the DM order also, Lordship, and restoration of physical possession. Lordship.
I will see. I will
Restoration of
see
physical possession. Lordship.
after hearing him.
My lords has already. got the
Having knowledge
opinion.
of this, your Lordship, they have taken physical possession. On
Unless
18th of
I'm-
May, 18th of
Just
May, they
only
have appeared
interrupting
before the
someone
justice
in
of-
between while he is submitting before the court.
Lordship, on 18th
My lords has
of-
rightly observed that this is a applicable order. What order is
Who
called
denied?
from my lord, that is upon my lords. It is better not to be dictated. That is my humble submission. Tomorrow,
Any junior can or by virtual mode you
Yes,
can
sir.
appear. You have heard from your side only.
I can stay, but my
There is
senior
some
cannot
problem,
stay.
Yes, I know.
That is why I have to go back.
my lord, I will be before his lordship tomorrow. morning.
Grateful, my lord.
Grateful.
Item 50.
Item number 15 minutes.
I am appearing for the petition.
This was heard earlier and stay order was granted.
Stay has been granted till August.
You are for opposite party. All opposite parties.
Only one opposite party
Only
and
one opposite.
another is pro forma opposite party, who is actually the son of the petitioner, who should have been the petitioner, but since he residing outside, so he could not
Okay,
come.
what is the matter about?
My lord, give me liberty to file a affidavit in opposition as because so many documents are there. Truth is withheld by the petitioner. as because
Let
I-
him complete then if I want to see whether.
But the
opposition-
issue is very simple. A suit for recovery of possession has been decreed against me ex parte. And I have challenged that ex parte decree under Order 9, Rule 13 of the Code of Civil Procedure, praying for setting aside of such decree on the ground that no notice or
Was
no notice was served upon me. And in support of my submission, in page number 80 of my civil division application, I have annexed one document, that is a summons, which was served upon me, claimed to have been served upon me by the bailiff by hanging. Lotkano service, by hanging they have served. They claim to have been served, and the witness, which is very important in our case, the witness who identified the house where I premises resides actually 10 to 15 kilometers away from my home, and he is neither related to me nor he knows me. Then how did he identify my home? That is
Anyone can identify.
anybody can
From
identify.
anywhere.
Anybody can identify.
Someone known to you. That is-
He is not known to me. He resides.
He know you, your residence.
Yeah.
Where is your residence?
If he knows that this is my residence,
Both-
then only
both
he can
the-
identify.
Both the witnesses has been examined.
No,
Belief.
no, ex parte
witness
degree, they were not examined.
Not examined.
Not examined. And that is my only contention in 913 application, that no notice was served upon me.
Order 9, Rule 13 was rejected.
No, this is pending for hearing. And the section 5 application, which was filed in that application, has been admitted, condoned, delay has been condoned, and the 913 application has been admitted for hearing. And now the execution proceedings was at full space. And I have filed one application for stay of that execution proceedings. In the execution proceedings, I have filed that application under section 151, read with order 21, rule 29 of the Code of Civil Procedure. I filed that
What is
application.
the stage of order 13, order 9, Rule 13?
The condonation of delay has been allowed
allowed
and
hearing.
hearing. It is for hearing.
Order number 13 is pending and next date is fixed for I think September.
September
In
for hearing.
September.
For hearing.
Allowed, give me a liberty to file a activity in opposition as because you have.
No opposition in CO.
My- I am-
There is no provision of,
Pre-suit eviction.
there is no provision of filing.
Madam, pre-suit eviction notice was served after the petitioner that was duly received by the petitioner. And petitioner is very much well conversant that suit may be filed very tactfully avoid.
Maybe-
The report reflected it is refused as because notice summon affixed to the door of the petitioner.
Why only one mode of service of someone? Why you have not sent through register post? Where is that? Can you show me any register post you have sent?
Give me 2 days time.
Why do 2 days time? From the judgment itself, can you show you have sent the letter to the register post and they have refused or good service has been made?
Naji report is here.
Even if
That I have
ex parte, why examination has been not done? Who exhibited the notice served by the bailiff?
It has not been exhibited.
So how trial court can rely upon it even if ex parte order has been passed?
Naji report.
Nazi report without any examination. Who exhibited that report?
It has not been exhibited.
Let the order 39 rule 13 be decided by the trial court. In the meantime, execution be stay. Otherwise,
That is only
it
my
will be
prayer.
infructuous.
Time may be fixed within such 6 months 1 year.
No, we cannot fix a time because Supreme Court has given direction that no particular time be fixed by the High Court or any higher court.
Otherwise,
I will request to dispose of that order 9 rule 13 immediately.
As
Expeditiously.
expeditiously as possible. Because we also want that matter should be disposed of. Until the time it is decided by the court, execution proceeding should be stay. Impugned order is,
Which order you have challenged?
yes, my lord. The impugned order is page number 103 of my revisional application.
103.
Yes, this is server copy. Subsequently, I have filed the original certificate copy by your supplementary affidavit.
Order 21 rule 9. What is this?
Execution of stay of execution proceeding.
Stay of the execution proceeding.
Order 21 rule 29 technically says when there is another suit pending with respect to same subject matter, the learned court below said order 9 rule 13 is not a suit. That is why I have framed my petition under section 151 read with order 21 rule 29. So in 151 the court has
CPC order.
enough power.
Order.
তো টেনেন্টও না বলে আনঅথরাইজ অপারেট না টেনেন্টস নোট আছে
And in order 39 rule.
Order 9 rule 13.
Order 9 rule 13, why you have not made an application for stay of the execution proceeding?
My lord, since I made the prayer in the execution proceeding, so I did not make similar prayer in the, because otherwise it will be barred by the adjudicator.
Just reduce a right order passed as because in execution proceeding, if there is a separate suit is pending or appeal, then allow. But with order 9 is a miss case. That's why that was it's a certain principle.
That is why I framed my application in such a manner that it is actually an application under section 151, because it actually does not cover by the existing provision of the Code of Civil Procedure. Because my case is peculiar, because my application for order 9 rule 13 is pending. If it is allowed, then the decree is set aside. If the decree is set aside and in the meantime I am evicted, then I will be in nowhere. I will be greatly prejudiced. So in such a situation, invoking of inherent power is absolutely necessary for ex debitio justitiae. And
From the JDF that the JDF have filed a present application under order 21 rule 29 CPC, which cannot be invoked in the state of the present execution case, since this application is legally not maintainable. In this context, also the court does not.
What about the section 151?
151. This is the inherent power of the court.
Inherent power. That should be state.
My lord, kindly see the last order of Justice Bhattacharya exactly on this point. The 151 should have been invoked.
So it is not that that application only taken into consideration when there is a 151 provision. If there is no specific provision that order 9 rule 13 is pending and that was admitted. If the execution has been proceeded, what is the fate of that order 39 rule?
Actually, it is a technical point, but petitioner.
Number one. Number two, the judgment passed ex parte, there on face of record, not appeared that the bailiff was examined, the witness were examined, how that report has been exhibited, how the ex parte order has been passed. You are unable to show whether that notice was served to him through speed post or AD with acknowledgement card. You do not have any document to show from the judgment itself that you have produced the document that
my lord.
notice was served properly to him.
After ex parte degree, also legal notice was sent and requested the petitioner to vacate the suit premises. That was also refused by the petitioner.
Then the entire suit will be decided in different manner. During pendency, how you can issue?
Not pendency. They are saying after during pendency of execution proceedings, they notice.
Execution proceeding, one legal notice was sent to the.
That's why they have filed order 9 rule 13 after knowing the facts.
Purposefully refusing that.
Where is that? You show the service was being done properly.
One day.
This is just mere allegation.
No allegation. I have.
Please show me from the judgment itself that where service was made properly.
One day conditions kindly be given. We'll give the letter.
How court can come to a finding that service was properly served?
My lord, the impugned order.
Which page it was observed that?
The ex parte order, page number 54 of my revisional application, para 20.
My lord, this
Para
is
20. This is an ex parte hearing, and when defendant after getting someone neglected to appear or did not take any steps to defend. Therefore,
That is the only
prima facie case
observation.
might fall in favor of the plaintiff if plaintiff has sufficiently proved and discharged the same by proving this case and therefore entitled to gain.
That is the only
How-
observation, and adverse inference has been drawn.
Where is that he was served notice?
Nothing. I
He
have read
refused.
the judgment carefully. Nothing.
Nowhere it is mentioned.
my lord. তুমি চিঠি পাঠিয়েছিলে বলছি পাঠিয়েছিস
The LCR called for.
My lord, the letter which was sent,
After expertise degree, requested the petitioner to vacate the seat.
No, after expiry, we do not want any notice. You may send, but prior to the expiry degree, is there any service?
Yes,
And
sir.
only on the basis of bailiff report, even if court can rely on bailiff report, but that bailiff report must be exhibited.
And that is
One-
my only
one-
point in the order 9 rule 13. That has to be decided that they can show their document that notice was served. My case will fail. Order 9 rule 13 will fail. Till the time it is decided, order 9 rule 13 is decided. Eviction notice is different. Eviction should.
Specific direction to file a suit.
This is an eviction notice. That is on the basis of this notice you have filed the suit.
Suit has been filed.
Suit is
going to be filed.
What is the observation of our coordinate bench?
But and specific observation that in these facts and circumstances, the court should have invoked the inherent power under section 151, and the court has already discussed such scope but refused to grant.
Someone was until this service of the sermon apparently by hanging in the road. The service was apparently identified the person inside. Without a proper identification could be made by such person from the impound or transferred to the degree premises either. And although it is well settled that the substance of the application is seen and not the caption, however, when a trial goes, despite of those observing the provision of section.
Para 3 of the order of the
Yes, hard for orders on earth. It should be stayed
Get full.
on earth for order.
In the disposal. Get full,
give a direction kindly.
Even in ex parte hearing, the court must examine the witnesses and satisfy with the oral and documentary evidence. Then only pass ex parte order. It does not mean that order side will not come and I will pass. Even if court rely upon the bailiff report, that bailiff report must be exhibited to show that the service was made. That is not on the record. Not even reflected in the
Order sheet.
order sheet. On what basis ex parte was declared? Can you show me the order?
Okay, my lord, given a direction to early disposal of this case,
Yes,
because
yes.
since long, the person is unauthorized
No,
occupied
definitely.
and purposefully, knowingly, is not appearing in this case.
No problem.
Get full.
What should be?
One indulgence, Lordship. There was a Passover matter, Lordship.
Pass over which item?
Item 9, Lordship.
pass over matter the 8 number and 9 number. 8 and 9.
Pass over matter item number 8.
देखिए item number 8 show করছে তো
Lordship, the preemption matter, the order, the preemption application
I am
filed.
dismissing for
Grateful,
default.
Lordship. Just for the record, Lordship, the preemption application which was filed before the learned trial court and before the first appellate court, they have been affirmed on behalf of the PT, on behalf of the respondents.
Your Lordship, then let me call my senior. I'll my.
So you asked him to call. I have passed over. Why? Why I have passed over this matter? Call him. Last chance I have given yesterday. His conduct is not good. Many occasions he has sought for adjournment and non-appears.
If this matter was filed back in the year 2023, if I'm not wrong.
Bang.
2023.
Oh.
In 2023, it was filed. The crux of the matter is that a preemption application was filed before the Learned Junior Division Alipurdwar. It was dismissed by the petitioners. It was filed by the petitioners. It was
On
dismissed.
what ground?
On the ground, they have filed a preemption application on 2 grounds. One, that they were the co-sharers and they shared the longest common boundary, which are the 2 conditions for being a
They have deposited entire amount.
that last date, I believe they have said that they have deposited, but I'm not sure. I'm not aware of the fact. That is, I'm saying upon the what I've heard on the last on the submission that they have made. And Lordship, moreover, one more plea that they have taken, that the certificate under posting under section 5.5 was not served. On all the grounds, it was dismissed. That's what I have derived from the petition.
In 5 minutes, Millard.
In this way, you cannot seek for adjournment.
No, Millard. It was.
It was passed over.
Yes, Millard. I was.
So tomorrow you be ready.
Tomorrow we'll do.
Tomorrow.
Grateful, as a Lordship is.
Namdev. For this
No,
matter,
yes,
I asked him to inform you.
Tomorrow, Millard, we'll do.
We always accommodate.
No, I know your Lordship, Millard. There's no complaint regarding that. That is the time here. Show number 10 is
16.
Grateful, Lordship.
Oh, 16.
Lordship, in this matter, I'm praying for our next circle, Lordship, because my senior Momini Rahman is going to the Hyderabad, Lordship, from personal medical emergency, Lordship.
Yeah. Please dismiss.
Good.
Yeah, sure. That was. Yes, 17, both side. 17, I am on behalf of the appellant insurance company. Notice has already start. There is a delay of tomorrow. Yes.
My lords, one indulgence. My lords, item number 30. I am for the petitioner. The opposite party is also present.
30.
Yes, my lords.
30.
30, my lords.
Yes, CO number. Both.
My lords, 84 of 2025, my lords. My
What
lords,
do you want?
my lords, we both have reached an amicable settlement. We've signed the new agreement as well. My lords, if it may kindly be, if our submissions may be recorded, joint submission, and it may be
You
dismissed.
file the joint application.
My lords, we'll withdraw the suit in the junior division, my lords.
So
My lords, kindly.
you want to withdraw?
Yes, my lords.
I am not recording anything. You
My lords,
just-
it may be kindly recorded that both are present and have jointly submitted that we've reached us, we have the agreement, my lords.
This is the new agreement which we have entered into.
But without
Without
filing, how I can record it?
My lords, only submissions may be.
You withdrawing, you are not prosecution.